Hello, everyone, and welcome to Uncivil Law. For today's case, we've got tax avoidance and tax evasion. We got some people trying to ditch on their taxes, and we got some people talking to the police and incriminating themselves, all kinds of good stuff. So this is United States of America versus Jamie Malo. In this case, some people were engaged in schemes to avoid taxes and all kinds of stuff. So we're going to read the story and learn why it's not good to talk to the police once again. Let's get started with this. In early 2015, the United States Internal Revenue Service began investigating Raphael after learning he had not reported some of his taxable income. Undercover IRS agents, feigning interest in buying one of Raphael's businesses, soon learned that he was taking unreported cash with him on flights to the Azores and depositing cash in a bank account that he maintained there. Secret bank account. Raphael explained to the undercover agents that he was able to smuggle cash through the airport because he had a connection in the Bristol County Sheriff's Office in Massachusetts, Antonio Ferretes, who could help him get past airport security. Raphael also told them that Jamie Malo, was a friend of his in the Bristol County Sheriff's Office. So yeah, like many people, he just tells people about his crimes. So that's always super encouraging. Raphael later told undercover agents he was planning a trip to the Azores on November the 10th, 2015. He repeatedly denied the undercover agents' request, however, to carry money for them on the flight. So, yeah, they're trying to set him up and give him some bait money or whatever, but no, he won't do that. But he'll tell them all about the crimes, so they're going to have to investigate a little harder, I guess. On the day of the planned trip, federal law enforcement agents set up a surveillance to track the movements of Raphael and his travel companions at the airport. Malo, who was also traveling to the Azores that day to manage the Thanksgiving at the Azores program, he ran through the Bristol County Sheriff's Office. That's hilarious. He has a Thanksgiving thing, and so he's going to celebrate Thanksgiving and also to deposit some illegal money. That's nice. Arranged for the sheriff's office van to pick up the other passengers, including Raphael, who are taking the same flight. So, yeah, he's got a connection in the sheriff's office to get him past security, and the FBI is setting him up and watching him as he engages with his sheriff buddy pals. And they've got them all on tape and all the rest of it. So, going down here at the airport, this Thanksgiving at the Azores parade. Nice. When Raphael went through the security checkpoint, agents for the United States TSA discovered he was carrying $27,000 in cash on his person. In response, the TSA directed Raphael to United States Custom and Border Patrol window, where he could declare the currency. Yeah, if you're traveling with more than $10,000 in cash, you actually have to declare it in your customs work. So yeah, you can travel with cash, you just have to declare it. So he didn't declare it, so they're, saying you have to declare it. Okay. Raphael then joined Milo on the plane. The two sat together in first class. Excellent. When the plane landed, the envelopes found their way back to Raphael. Soon thereafter, he deposited $76,000 in cash in his personal bank account in the Azores. Law enforcement continued investigating the cash smuggling team after the November 10th, 2015 trip. Sometime thereafter, in consequence of the investigation, Raphael pleaded guilty to charges of conspiracy, bulk cash smuggling, and tax evasion. Freitas, for his part, was convicted of related crimes after a jury trial, so they did eventually get busted. Special Agent Allison Pauley of the Federal Bureau of Investigation and Special Agent Ryan of the United States Department of Homeland Security traveled with Milo to request an interview. So now we are going after his co-conspirator, Milo, the guy in the sheriff's office. So we got the guy, we found him carrying money to the Azores, and we got all that. But now we have to go after Milo, his co-conspirator. So now the FBI says, we'd like to talk to Milo. So let's go talk to Milo, who is our protagonist in this story. Everything else now has just been setting up the story. Milo is the heart of our story today. Okay, so they showed up at his house, and Milo consented to the interview and invited agents into his residence. Okay, Uncivil Law fans. Milo consented to the interview with the FBI and invited the FBI into his home. Uncivil Law fans, what two critical legal mistakes did Milo make in this interaction? Please enter your answer now. During the course of this interview, which Milo's attorney John Zazak participated by phone, and the fact that John is participating by phone means he's not a very good attorney. He should tell his client to shut the heck up, and if they're going to do this in person. But his attorney decides to be on the phone, which is not super encouraging for John Zazak's legal skills over here. Milo admitted, among other things, that he had passed envelopes to Raphael's behalf to other passengers on the trip and have them carrying envelopes for Raphael on the flight. So he's admitting to all kinds of things, and his attorney is on the phone, and his attorney is allowing him to have this conversation. I can't believe his attorney is allowing him to do this. If you were my client and you called me, I tell you to shut up. And if you say, I want to have the interview, I tell you, no, we're not going to have the interview. And I say, I'm going to do it anyway, then I'm hanging up the phone. I'm hanging up the phone. You're on your own. I'm not participating in this call as your attorney on remote. There's just no way. I've given you my best legal advice, which is to shut up. If you're going to defy my legal advice and have the conversation anyway, I am hanging up the phone. The fact that his attorney allowed him to be on the phone and have this conversation is not super encouraging. You have to actually be in the room for body language reasons and all kinds of reasons. This is just not good. On October the 25th, 2017, a grand jury in the District of Massachusetts handed down a 3-count indictment against Milo over here, the sheriff's assistant or whatever. The indictment charged him with engaging in conspiracy in violation of law, bulk cash smuggling, aiding and abetting in violation of law, and structuring the export of monetary transaction. Structuring is a wonderful little offense. Structuring is where you're purposefully trying to put your money in arrangements so the cops don't know it. So for those of you who don't know, like if you deposit more than $10,000 in cash in a bank, the bank fills out a report. There's nothing illegal about it, right? The bank fills out a report. And what structuring is you're purposefully putting in less than that amount for the purpose of trying to evade that. So like you're purposely trying to evade it. So incidentally, like when I transfer money, I never, I always recommend to people if they transfer money to transfer it in $10,000 increments. So like if you have money from a savings account to a checking account, if you can afford to do so, do it in $10,000 increments. It's fine, and there's nothing illegal about it. It's your money. The bank will make a report, but what do you care? It's legal, and then you don't have a structuring problem. So yeah, if you purposely try to put the money below the threshold, that's structuring. It's a federal offense to try to evade that detection. That's structuring. And so the structuring here, by the way, in case you're wondering what was the structuring, he admitted that he gave the money to other passengers, right? Because it's illegal to not have it's illegal, well, not illegal, but you have to have $10,000. If you have $10,000 in cash, you have to declare it. So he was structuring by giving the money to other people on the plane, who apparently are trustworthy, I guess. He was giving the money to other people on the plane so that no person was above the threshold. That's the structuring violation. So when he admitted, I gave the money to other people on the plane, he admitted to structuring. There you go. The district court's a jury found him guilty on counts 1 and 3. So they found him guilty on the conspiracy and the structuring, but not on the actual bulk cash smuggling, aiding and abetting. The district court subsequently sentenced him to 1 year of probation, so not too bad. Milo finally filed a notice of appeal. So Milo over here has been convicted of structuring and of conspiracy, but not of the actual violation of the deposit of money. So good for him, and as a result of that, he only got a 1 year suspended sentence. But he's still going to appeal because he's sad about his criminal conviction. So let's read more about why he's sad. We start with Milo's challenge, based on Miranda, to the district court's denial of the motion to suppress statements he made to them during the interview. The district court rejected the motion on the ground, although it was not an easy case. Milo did not need to be given Miranda warnings, which were only given after he was arrested following the conclusion, before or after, because he was not then in custody. Yeah, Miranda only applies if 2 things are true: custodial interrogation. The police were definitely asking him questions. The question was he in custody at that point? And the answer seems to be no, he wasn't. He was in his own home and all that stuff. So no, he wasn't in custody. So Miranda didn't apply. They didn't have to warn him. They only warned him after he arrested him, after he already told them everything. So yeah. Because there's no dispute that the agent subjected Milo to interrogation through questions that they asked during the interview, the need for Miranda warning in this case turns on whether he was in custody. To determine that, we employ a 2-step process. The initial step is to determine whether, in light of an objective circumstances of the questioning, a reasonable person would have felt that he or she was not at liberty to terminate the questioning and leave. So, did you feel free to say, I don't want to talk to you anymore, and or leave? That's the relevant question. We have previously identified a non-exhaustive number of circumstances that are relevant to this type of aspect, including whether the suspect was in question in a familiar or at least neutral surroundings, the number of law enforcement officers present, the degree of physical restraint placed upon the suspect, and the duration and character of the questioning. In conducting this analysis, we keep in mind that a finding of custody depends on objective circumstances, not on the subjective views harbored by either the officer or the person being questioned. So it doesn't matter what you in your own head thought, the question is objective. Would a reasonable person in this situation feel unable to leave or feel like they couldn't stop questioning? That is the relevant question here. This inquiry into whether an individual freedom of movement was curtailed, however, is simply the first step in the analysis, not the last. Once we complete the freedom of movement step, we must still ask the additional question of whether the relevant environment presents the same inherent coercive pressures as the type that a station house questioning was present in Miranda. In considering the circumstances in which the questioning took place here, we note at the outset that it was conducted in the home, which as always is special. That has some significance because a suspect's dwelling may at times comprise custodial interrogation. Such a location generally presents a less intimidating atmosphere than a police station. Yeah, it would be a much more familiar environment and therefore might be more beneficial to the police depending on what they're trying to accomplish. But, you shouldn't feel more familiar in your own home than in a police station. We note two other features of the setting in which the interview occurred that support the district court's custody ruling. The first is that, although the agents were in the home for 3 hours, they repeatedly interrupted their questioning at Milo's request to ensure his attorney could participate by phone. And his attorney participating by phone is not a super encouraging sign. I would not want to do this via phone. This does not sound like a good plan. The second is the district court determined the agent's tone during the questioning of Milo was cordial and professional. Milo contends the district court erred in finding that the setting for the interview was not custodial, in part because he contends the record clearly shows the agents communicated to Milo and his attorney that they intended to arrest Milo if he was not truthful and cooperative. Well, they might want to arrest you, but, you're giving them all the information to help, so that's a whole nother set of problems. Milo asserts this point is critical because even though a police officer's subjective view of the individual under questioning as a suspect, if undisclosed, does not bear on the question of whether an individual is in custody. So whether the officer thinks that it's a suspect does not change the Miranda analysis. When agents convey intent to arrest, as the agents clearly did here, that figure should factor into the analysis. So the fact that they threatened him arrest, maybe that changes it. Yet, Milo contends the district court failed to factor in the statements he alleges the agents made into his analysis. Even if we were to assume the legal contention about the significance of the statements has force, Milo still needed to show the district court erred and declined to find those officers in fact made those statements. Milo notes neither of the agents denied in their own testimony at the hearing that Zajak asked them whether they intended to arrest Milo. Rather, they merely stated that they could not remember Zajak asking that question. So the agents don't say, no, I don't. They just say, I don't remember it. For example, when asked if attorney Zajak asked whether you definitely were going to arrest Milo, the agent responded they did not recall that question being asked. But a review of the record shows that although the agents said they did not recall if Zajak specifically asked them whether they intended to arrest his client, both agents were unequivocal in stating they did not convey an intention to arrest if he failed to cooperate. So they said, no, we didn't say we would arrest for failure to cooperate. For example, when asked whether they ever communicated Milo had gone to arrest if they didn't cooperate, they said no. In addition, the agent affirmed they never disclosed their intention to arrest Milo that day. Thus, nothing Milo points to the record indicates the district court clearly erred in declining to find the agents expressed the intention to arrest Milo if he failed to cooperate, as Milo contends they did. So, this, at least is turning on a factual question. The factual question at point being, did the agents threaten to arrest if he didn't cooperate? And the district court, which again, remind you, is a trier of fact. The district court heard the testimony from Milo over here, and presumably his attorney, and also heard testimony from the agents. And the judge, being the trier of fact, says, I don't believe the agents said that. I don't believe that's the thing they did. And so it factually didn't happen, right? So yeah. So therefore, if the agents never threatened to arrest if he didn't cooperate, then we don't have to factor that in. So the trial judge didn't err by failing to factor it in, because as far as the trial judge was concerned, it didn't happen, because whether or not it happened is a question of fact, and they're the trier of fact. So they say, well, it didn't happen, so I didn't factor it in. And the appeal court said, yeah, that's not clear error. The judge listened to all the relevant people and all the relevant testimony they give, and then chose to believe some of them and not other people. That's something a trier of fact gets to do. So the judge did not do an oops by saying, yeah, they simply never said that, so therefore I didn't factor it in. That's something a trial judge can do. In addition, the record shows that Milo did not include him in his assertion about the agents expressing intent to arrest him in an initial affidavit given after the interview. Instead, he made this assertion for the first time at the motion to suppress. So Milo, in his affidavit describing the interaction, didn't say, the police said this to me. He only brought it up in the motion to suppress, which also might somewhat might say maybe you're making it up, because was your memory sharper then or sharper now? It's not in your affidavit, so you're not saying the same thing. So that might be another reason to disbelieve you. As a result, the district court supportedly could have found the account Milo gave at the hearing was less than convincing in the light of his previous affidavit. Considering the record as a whole, therefore, Milo's challenge to the district court's custody analysis fails insofar as it depends on the record, requiring us to conclude the agents told Milo he would be arrested if he didn't cooperate with them, even though the district court found to the contrary. Milo argues in particular that if the district court had taken full account of the restraints on his movement that he contends were placed on him while he was questioned by the agents statements about him being the target of the investigation, when combined with him having imposed their restraints, compelled a finding that he was in custody when they were being interviewed. Milo's contention the district court clearly erred in finding he was free to get himself water during the interview fails because there was ample testimony at the suppression hearing to the effect that Milo was free to get up and get water. So, Milo's contention that he was free to get up and get water is belied by the fact that there was plenty of evidence to that effect. The record also shows that one of the agents once got water on Milo's behalf does not persuade us the district court erred in finding as it did on that score, especially as the agents testified they never told Milo he couldn't leave the kitchen table or otherwise move about their home. So, again, the district court, which is considering this motion to suppress and considering the evidence from people in the motion to suppress, says, no, having considered all the evidence, I simply don't believe that the officers prohibited you from moving around. They might have once gotten you water, but they say they never prohibited you from moving. So again, I, the district court, choose not to believe you and believe them. Also in light of your own affidavit, which seems to somewhat contradict what you're saying now. So yeah, I believe them and not you. So again, that's something for the jury, something for the judge as the trier of fact in the suppression hearing to figure out. Given other testimony that was provided at the hearing regarding Milo's freedom of movement, which included undisputed testimony that Milo did move around his home at various test points during the interview, we find the resolution of this one factual dispute immaterial to the determination of the overall custody analysis, which is supported by the record. That leaves us with Milo's contention that the district court improperly analyzed the significance of the agents monitoring Milo as he proceeded to use the restroom. But even if we set aside any consideration of the subjective motivation of the agents and focus solely on the intrusiveness of the monitoring, the district court here found that the agent observed Milo closely when he had to go use the bathroom, but did not go into the bathroom with him. As Milo does not argue there's any aspect of the factual finding that was erroneous, we do not see how this finding is sufficient to compel a conclusion his movements were so restricted as to warrant a finding. So the agents watched him as he went and got up and went to the bathroom, but they didn't actually go in with him. They just simply watched him walk to the door and then presumably waited for him to emerge and perhaps listen by the door for any erroneous signs of flushing of drugs or something. But, that just seeing you go up and walk towards your restroom is not it does not a custody make. If his Thaddeus in chat asked me if his lawyer was present, does it matter if it was custodial? Yes, it absolutely matters if it was custodial, because his lawyer being present does not in any way change the fact that Miranda has to be provided, because you have a right to remain silent, and you have to be informed of your right to remain silent. And if your lawyer doesn't do it for you, which, this guy not being the sharpest lawyer I've ever seen in my life doesn't seem that unlikely, you have to be informed. You have a right to remain silent. Anything you say can be informed, all that good stuff. So yes, the fact his lawyer was actually present does not change the Miranda analysis. If Miranda has to be given, it has to be given, even though his lawyer is present. So, yep, doesn't change it one way or the other. His lawyer may not be the best lawyer, is also a factor in this. I'm figuring out. Milo was never told he could not leave the kitchen. His home was not full of armored agents during the questioning, and there's no indication law enforcement purposefully tried to separate Milo from his wife at the beginning of the interview. So that brings us to the end of the case of United States of America versus Jamie Milo, who may not have the greatest lawyer of all time, who decided to allow his client to conduct a phone interview and allowed the FBI to do that. And just no, that doesn't sound like a good idea. And Jamie over here was never read Miranda, but he wasn't in custody. So the lessons here learned, as always, are one, don't talk to the police. If the police say, I want to do an interview with you, just say no. And say, I demand to have a lawyer present, and then meet with your lawyer in advance of the meeting and have your lawyer do all the talking. That's always a good plan if you're going to do this. But just don't would be also a really good start. So Jamie here violated the cardinal rule. He talked to the police, and as a result of that, his 1-year suspended sentence will remain intact. And that is the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.